Hi there, this is Kaushik Ranchod. Welcome to our immigration show. Today we are talking about the hardship, J1 Hardship Exceptional Waiver. Exciting stuff, so stay tuned until the end because we're going to do two case studies. One from a client where we got an approval for a country from the Middle East, and then one where we got an approval from a country in Latin America. And so we will compare, contrast, look at the different types of hardship. And if you like this video, please smash that like button. And you can post your comments below, but let's dive into it. Let's not waste any more time. So first of all, I'm gonna talk about the case study for our client from Yemen. And he married a US citizen in the United States. So in order to qualify, you do need to have a qualifying relative. You can't file a hardship waiver without having a qualifying relative. So you might be asking, what's a qualifying relative? Well, a qualifying relative is a US citizen spouse, a permanent resident spouse, or a US citizen child or permanent resident child. Now, what it's not is not a US citizen parent or a child or a brother or a sister or aunt or an uncle. So I want to make sure we got the basics there. Okay, let's dive back into those hardships. So in this situation, they got married and she was a Christian. So the US citizen was a Christian and a proud American. So Yemen would not be a safe place for her. Additionally, she could not continue her education as well in Yemen. We were also able to make a case based off of emotional hardship. Emotional hardship if they were going to be separated for 2 years. Now, making the argument for emotional hardship needs to be something that's beyond mere separation. The hardship that you would face through that, it's something that's above that. So if it triggers something such as anxiety, depression, if you have a history of that kind of medical condition, that could be a form of emotional hardship. In this situation also, the couples were living a very frugal lifestyle. They were both studying, so they needed both incomes as well, and that would be disrupted through the separation. And we were able to make that argument as well. So you can see here, there was a variety of factors. There just wasn't one like magic bullet, like boom, that knocked it out. No, we had emotional hardship. We talked about financial hardship. So we stacked all of these things together. That created the hardship argument. Now, another question I'm getting is like, well, how much time should I allow to apply for this? So in the good old days, hardship waivers were taking around 4 months. Now, and the worst that I've seen is around 2 years within the last few years. And it can range anywhere between those times of, well, it's not 4 months anymore. It's more like the best that I've seen recently is around 6 to 8 months. Usually our cases right now in 2021 are getting approved anywhere from a year, could be a little bit longer, could be a little bit less, but these are just averages of government processing times, and each case is unique. So I would give yourself plenty of time. Give yourself up to 2 years, plan accordingly. The worst mistake that I see people, well, one of the worst mistakes I see people make is waiting too long. And then they have to figure out, well, what am I gonna do while I'm waiting for my J1 hardship waiver? I don't want you to be in that situation. Now, the other question I get is, well, is this the appropriate waiver for me? So if you're a physician, you know that you might have an option of the Conrad 30 waiver or the VA waiver. And that locks you into the 3-year requirement with that employer. So people like the flexibility of the J1 hardship waiver. Or you may not be eligible for the no objection waiver because you're subjected to, or you're not eligible for it depending upon what kind of funding you receive. You got US government funding, you may not qualify. So if the no objection waiver doesn't allow you to apply, if you're not able to apply for the no objection waiver, this is a good option. And of course, physicians can apply for no objection waiver as well. So the hardship waiver is a good alternative, and I invite you to contact us if you have more questions about it, but I know you're waiting for case study number 2. So let's dive into that. This is a client from Latin America where we got his case approved. So similar to the other case, while he was in the United States, he got he met and married a U.S. citizen while he was in the United States. Now, a little bit of a different scenario in this situation is that in this situation, the couple was expecting their first child. So another question I get is, well, does the pregnant child count as a relative? So qualifying relative. So the pregnant child is not born yet. So you can't, if you're pregnant, but you're not married to a U.S. citizen, you're not going to be able to qualify based off of the pregnancy. But typically, if you're pregnant, you're also married to a U.S. citizen or permanent resident. And this is an extra form of hardship, and this is what we were able to argue in this situation, in this case. Specifically in this situation, the child was due 2 weeks after the applicant would have to leave the United States. So here you can begin to see that exceptional hardship building and building and building. And while you're listening to this video, put yourself in the eyes of the officer and listen to, well, when does this reach the threshold of exceptional hardship? And that can kind of give you a better idea when you're evaluating and thinking about what your own hardships are. And I'm hoping that this video will help you think of your own personal hardships, because I know sometimes you can be so close to the situation that it's hard for you to think of, well, what are my exceptional hardships? And that's what we like to do, is talk to you about your life, about your situations. And as a third party, we can see your life and be able to analyze what your exceptional hardships are. In this case, we're also, similar to the other case, able to make an emotional hardship argument. Part of that was the pregnancy, how the emotional hardship would rise to a higher level because of the fact that, imagine being pregnant and having your spouse separated from you. So that is how we tied in the emotional hardship and made an argument of emotional hardship. That was one of the key components. In this situation, the wife was also financially dependent on the applicant. So we were able to make that financial hardship argument as well. Another factor of hardship was that the health insurance was through the client's employer. So of course, if our client left, then she would lose her health insurance. Now, that's not a great thing to have happen to you when you're expecting a baby, because we all know that a pregnancy is super expensive. So that is another form of hardship that we argued, that especially during the time of a pregnancy, losing health insurance, and just losing health insurance in general, is another factor that we can argue. Another factor was that the U.S. citizen didn't speak the language of our client's home country, so that would be another form of hardship as well. And then also career hardship, that her career would be disrupted as well. So we were able to make all of these arguments to get the hardship waiver approved. I want to thank you for tuning into this video, and if you would like, please post your comments below. Call us if you have questions to see if you qualify, because every case is unique. Every case has its own unique factors. So we'd like to look at those factors to determine whether or not you think you have a case. And until next week, thank you. Bye for now.